Thank you so much for joining us, the Pride Center and Coast to Coast Legal Aid. Well, we've experienced some technical difficulties, which means that you're not watching this live. We have pre-recorded this. So unfortunately, we're not going to be able to take your questions in the comment section below, but we're really glad that you joined us. My name is Christopher Fagenbush. I'm the COO at the Pride Center at Equality Park. Our mission statement says that we provide a welcoming, safe space, an inclusive home that celebrates, nurtures, and empowers the LGBTQ plus communities and our friends and neighbors in South Florida. And that's what we hope to do through this video, is create a welcoming, safe space for you and for those you love. If you're like me, you probably know some folks that were in an unsafe housing environment during this coronavirus pandemic. So during this little video, we want the Pride Center and Coast to Coast Legal Aid, we want to, as part of our collaborative series, learn about legal rights. And so we're going to be looking during this conversation at domestic violence, intimate partner violence, temporary injunctions, family law, divorce, child custody, family law, and remote hearings in 2021. So yes, that is a mouthful, but we want to equip you and those you love with the good knowledge so that you know what your legal rights are, and maybe you have some ideas of steps you can take to protect yourself and protect those that you love. Joining me this evening is our Marketing Communications Manager at the Pride Center, Nick Zantop. Nick, do you have anything you want to add to that before we introduce Alicia?
Just a huge thank you to our amazing partners at Coast to Coast Legal Aid. It is a real pleasure to be with you tonight and a real honor. Your knowledge and expertise is so incredible, and we really appreciated you being able to join us a few weeks ago for the first of this two-part series. Lots of really great information. And for folks out there who maybe haven't watched that first part, which talked all about housing rights, definitely go and check that out as well. Thank you all so much for being with us tonight. Really appreciate it.
I thought I had muted self, but I had not. So I do want to welcome one of our favorite collaborators in the community with Coast to Coast Legal Aid, Miss Alicia Harwood.
Hi, Christopher. Hi, Nick. Thank you. So I have the pleasure of tonight introducing our guest panelists for this clinic. So I'm going to start with David Hirschberg, who is here pro bono tonight, donating his time to this clinic and providing this information to the community. So welcome, David. To give you a little information about him, he is the founding member of the law offices of David L. Hirschberg. He is board certified in, and I always read this because I switch the words around every time, marital and family law, and he's on the executive council for the Florida Bar Family Law section. On a personal level, he is a runner and into Peloton, and he described that he has 2 wild and crazy sons, and they are Star Wars obsessed, and it is May the 4th, so May the 4th be with you. And that ties into our second presenter, Shaina Finkelstein, because both David and Shaina are double Gators. They have an undergraduate and a law degree from the University of Florida. So we are surrounded by Gators tonight with it. And Shaina is a former public defender with the Miami-Dade Public Defender's Office. She joined Coast to Coast Family Law Victims of Crime Unit, where she represented victims in intimate partner violence cases, and has recently shifted to also represent our 60 plus population here in Broward who are victims of crimes. On a personal level for her, she has 5 chickens, which we have seen oftentimes in our staff meetings, and also a rescue pup named Jojo. So I don't know if any are going to make an appearance tonight, but we always welcome that. We had pugs at the last one, so we're always welcome for any kids, pugs, chickens, any of those things. But thank you both for joining us tonight to provide this information to us. And I always give the legal disclaimer, and I keep it short, but putting it out there that this is a legal information clinic. It's not legal advice. You're not forming an attorney-client privilege with Shaina or David or myself even. And all of the information is current as of today, May the 4th, 2021. So I'm going to turn it over to Chris to start with some of the hosts and questions.
Absolutely. And Alicia, let me apologize for not doing a really good introduction. Some folks may not know you in the community. Alicia D. Herwith is the Chief Operations Officer at Coast to Coast Legal Aid and has spent the past 14 years focused on social justice and public interest law. And I know has really done some amazing specialty practicing work for the last 8 years in housing rights. In that time, she's focused on persons living with HIV/AIDS, the LGBTQ plus communities, veterans, and seniors. And I know that Alicia serves on the board of directors for Poverello, our next door neighbor. So with that, we're going to jump into some questions, and I'll let our audience know that's watching that David and Shaina both are going to be sharing information with us tonight. David is going to be sharing some information in the areas of family law, going to be giving us some insight into divorce, into custody cases, alimony, child support, marriage equality issues, and that Shaina is going to be sharing with us some information on domestic violence cases, intimate partner, non-intimate partner violence, different sorts of things. So what I'm going to attempt to do tonight, recognizing that the audience watching this video may be coming tonight with different sorts of legal concerns, is we're going to try to weave a dialogue and conversation that's going to involve both Shaina and David. So we may jump around a little bit from topic to topic, but hopefully you watching as our audience know that we're going to try to get to the questions that you may be coming tonight in your mind, or today, whenever you're watching this, in your mind with questions. So Shaina, if you feel comfortable with me starting with you, as I mentioned during the introduction, I know in my own life and in my own work, had to work and attempt to help and support some folks during the pandemic that were in unsafe housing situations. And that may be due to domestic violence or intimate partner violence situations. We know young people that may be stuck in a situation living with family members that are not supportive or abusive towards them. We may know seniors that have caregivers that were really stuck in an unsafe family situation. So I guess a good opening question is to dive right in. From your perspective, Shaina, what can victims do to try to stay safe during these times?
That's a great first question. Thanks for having me tonight. So I guess the answer will kind of depend on your individual circumstances. So there's different avenues that are available to you depending on your situation. Right now, you can still petition for injunctions for protection against domestic violence and repeat violence, sexual violence, stalking, all dating violence. All of those injunctions are available. You can still go to the courthouse in order to petition for them. Through an injunction, you can get exclusive use and possession of the home. But I do recognize that depending on the variety of situations you just described, that may not be what you want, where you may not want to be the one that stays in the home. Maybe you want to find somewhere else to go. For people in that situation, we often refer people to Women in Distress, No More Tears, or Jewish Goodman Family Services. All offer types of safety planning and possible relocation services, kind of depending on what you're looking for. Women in Distress obviously offers immediate emergency shelter assistance if that's the kind of danger that you're in, that you want an immediate place to go. But there's also they also can help you plan to where you're going to live more permanently in order to get maybe the rental assistance or things you need. And if you go to one of those places, they can help figure out what your needs are. And we'll include some of that information in the description in terms of those phone numbers or places you can go.
Now, Shaina, I heard you use a term that folks may not know, an injunction for protection. Can you tell me what that means and maybe when it's appropriate to file such a thing?
Yeah, so injunction for protection, most people probably use the term restraining order. That's the term we probably hear on TV or in movies or when we're talking. And so what it really is an order from the court that says that someone has to stay away from you, both physically and that they're not allowed to have contact with you, direct or indirect. When you petition for an injunction, if the facts you put in your narrative rise to the level, then you can get a temporary for the time period, and then you'll have a hearing. So it's appropriate to petition for an injunction if you're a recent victim of violence. Now, if you are in a domestic relationship with this person, you don't even necessarily have had to suffered any violence yet. if you have reasonable cause to believe you're in imminent danger of becoming the victim of domestic violence. Essentially, if you're living with someone that's threatening you, if things are escalating, you're afraid that they're going to hit you, you don't have to wait until you get hit in order to petition for an injunction for domestic violence. But that is unique to those types of injunctions. Most other forms of injunctions, there does need to actually have been an act of violence or assault or stalking. But in the domestic violence scenario, because the parties are in such close quarters, especially in times of COVID, the courts recognize that you shouldn't have to wait around to get hit if you really are in danger.
So is that the main difference if I'm looking to try to determine I'm going to appropriately file for an injunction versus a domestic violence injunction? Is it that idea of I could potentially be in danger with the person that I'm living with? What's the difference of when I should file for a domestic violence injunction as opposed to another type of injunction?
That's a great question. So domestic violence injunctions are appropriate when you are domestically related to that person. And the way that's defined in Florida is basically you've had to have lived together as if a family. So that obviously usually will apply to your family members, and immediate families members. But the only person that you are domestically related to that you never had to have lived with is someone that you have a child in common with. So someone you have a child in common with, you never had to have lived with them. Otherwise, it's people you've lived together as if a family. So you don't necessarily have to be in a romantic relationship if you live with someone else, but you guys share groceries and it's domestic. That's the way it's defined.
Okay, that makes sense to me. So what type of injunction should you apply? Say my abuser is someone I dated in the past, but we never lived together as family. What would be the appropriate injunction for me to look at?
So most likely the injunction that's appropriate would be dating violence. However, for dating violence, I believe you have to have been dating recently, right? It can't be like a very old relationship. So it can get a little technical when we're talking about that. So sometimes if it's been a long time though, maybe stalking or repeat violence is necessary. So it has to have been a relationship that existed within the past 6 months.
That's what I was going to ask, is what does recent mean to the courts?
Right.
Like my romantic view of it may be different than the legal. So we're talking 6 months?
The relationship had to occur within the past 6 months. Otherwise, it's possible that another type of injunction is appropriate, such as one against repeat violence or stalking, depending on the way, I guess, that they are abusing you currently. Yeah, go ahead.
Sorry, go right ahead.
So repeat violence, again, as you can tell from the name, there has to be more than one incident. There have to be 2 incidents of abuse or stalking. And one of those has, again, a lot of those types of injunctions, the things have to be more recent. The reasoning being that when you live in the same home with someone, the requirement for things being recent is not as important. But obviously stalking, even though it doesn't say in the definition it has to be in the past 6 months, it's going to be hard to prove to someone that someone's stalking you if they haven't even done anything to you in the past 6 months. So it kind of becomes a requirement, even if it's not written in.
What if it's not someone that's an intimate partner or has a history of an intimate partner? What if it's a family member? What if I'm living with a parent or an aunt or a grandparent or a sibling? What are my options for injunctions in that situation?
Because you're living with them and they're a family member, you're acting as if a family, that would be a perfect appropriate situation for domestic violence. It gets more complicated when it's like a neighbor or like someone that you never dated, someone that it's a lot of those times it's going to fall under stalking or repeat violence, depending on the situation. Stalking violence, though, it's the hardest injunction to prove, in my opinion, just because stalking has so many elements to it. In order to prove it, it's someone has to engage in a course of conduct directed at a person with no legitimate purpose other than to harass or annoy that is likely to cause substantial emotional distress in that person, and which does cause substantial emotional distress in that person. And I only know that definition because I have to explain it to people all the time why it's so difficult to prove. Because if someone has a legitimate reason for contacting you, like you have a kid in common or you owe them money, then you're not going to meet the value for stalking. Or so it can be very hard to prove, especially when it's an ex who it's a long time relationship ago and they're just still bothering you. And then you have to prove that that would cause emotional distress in the average person, that even if they're not threatening you, but they're dropping off your belongings like years afterwards, is that a legitimate purpose? They're giving your stuff back? Or is that something that would likely cause substantial emotional distress in a person and really isn't for a legitimate purpose? And that's where it gets difficult to prove.
Shaina, thank you for that. I'll let you know now. I do have some follow-up questions on this, and I want to get back to that. But I also want to make sure that, David doesn't nod off in the corner right now. So I'm going to, if you're okay with that, I'm going to take and turn attention for a few minutes to David, because I'm also aware during this pandemic time and families and friends and roommates and other folks kind of being locked in close quarters, it has produced all sorts of challenges for people in communication and relationship. And unfortunately, that means that there are family units that we know that have dissolved during this time. And so I do want to kind of turn our attention, if we can, for a few minutes to some family law issues. And so can we have a conversation just for a few minutes, David, about divorce? Because that is a reality for many couples in our communities that we're facing right now, is unfortunately, they are facing imminent divorce and divorce proceedings. So, David, are there different types of divorces in Florida? And if so, what are they?
First of all, I wanted to say thank you again for having me and for inviting me. And it's an honor to be here, honor to be here with Shaina. And Coast to Coast Legal does amazing work in this community, and I have a lot of respect for it. There are different types of divorces in Florida. There are obviously divorces where there are minor children. There are divorces without children. And then there's something called a simplified divorce. A simplified divorce is where the parties don't have children, they don't have joint assets and liabilities, and that's what makes it simplified. Do you want me to expand on that, or
yeah, can you? Nice terms, and it's helpful for me because I need to know the terms. But why do you unpack those? Like, what does that mean? What do those mean? What are the differences in those?
Absolutely. So if the parties have no assets and they have no jointly titled assets and no jointly titled liabilities and they have no children, they can participate in what's called the simplified divorce process. Simplified divorce.
Hey, David, let me just interrupt you for a second, just because some of us don't always know the legalese of this. When you talk about assets, are you talking about like we own a house together? Like what gets included under that when we're looking at those resources?
So assets really is anything. So you have what's real property, like which would be real estate. It could be a house. It could be investment land. And then assets could be anything like a car. It could be a bank account. It could be a retirement account. It could be debt, liabilities. So that could be credit card debt. That could be a mortgage. So, assets.
So if we have joint credit card debt, we have assets.
Well, you have a joint liability. You may not have any assets. You may not have anything together. But really, it's and then you also have to understand that what the definition of joint means. Joint could mean that it's on title, and both of you, it's titled in joint names. That's one way. The other is, do you have any marital assets or marital liabilities? Because anything that you acquire during the marriage, regardless of whose name it is in, is presumed to be marital. So which will be assets or liabilities. So sometimes someone might be going to work, they might be contributing to their 401k plan. And even though it's in their name, it's considered marital, whatever those contributions are during the marriage. These are financial issues that unfold. When the parties don't have anything jointly titled, and they don't have to exchange assets or liabilities, and they just want to sign the divorce papers and be done. You keep what's in your name and I keep what's in my name. They can go through what's called a simplified divorce process. If they don't have that, and it's not simplified, meaning they have children or they have assets and liabilities to distribute, then they have to go down what's called the regular dissolution process.
Thanks for unpacking a little bit of that. I've heard this phrase like a no-fault state. Is Florida a no-fault state? And if so, what does that mean?
So Florida is indeed a no-fault state. And some states are called fault states. Some states are called no-fault states. Some states have a mixture. Florida is a straight no-fault state. There's only two requirements to get divorced in Florida. One of the parties has to be a resident of the state of Florida for at least 6 months prior to filing. They both don't have to be, but one has to be. That doesn't mean you have to be physically present in Florida all 6 of those months, but Florida has to be your home, your residence. The second requirement is you have to use the magical term irretrievably broken, which means there's nothing that the court can do or say to repair your marriage. That's it. The court does not get into why you want a divorce. The court does not get into whether one party caused the divorce. That's what means a no-fault state. You don't have to prove fault. In fact, the parties can be residing together in the same residence and go through a divorce. Some states require physical separation for a certain period of time before they can go. Not Florida. Even if one party stands up and says, I don't want the divorce, as long as one party says the marriage is irretrievably broken, then the divorce can go forward. That's why we are a no-fault state.
So it only takes one.
Only takes one.
So does that mean like cheating, adultery plays no role or has no significance in the cases?
I guess I have to give you the standard family law answer, which is maybe. Morality-wise, it doesn't matter. There's no morals in the law because, one party will stand up and say, he cheated on me and I deserve more money or deserve more consideration. And then the other party stands up and says, I cheated on my spouse because they didn't pay attention to me, or we have been intimate for 8 years. The court doesn't get into those morality things. That doesn't have relevance. Cheating can have two relevant points in a divorce. One, is that cheating affecting the parenting issues? Is the person you're cheating with a bad influence on the children? Do they have a drug or alcohol problem? Did you inappropriately introduce the new significant other? That's where it can have a impact on the parenting. The other place that cheating can have an impact is if it's financial. So if you are spending, because there's something called dissipation of assets. If you are spending a lot of money on your significant other, if you are buying them expensive gifts, expensive dinners, if you are taking trips with them, that's called dissipation of assets. That can have a relevant point. But those are the only two places where cheating can have an impact on divorce, where it becomes relevant to the court.
Absolutely. That makes sense to me. I understand that. What are the typical issues you see in your practice in a divorce case?
Are we talking about COVID or are we talking about in general? Because,
well, let's go both of those in that order. Let's say, like, what are the unique things maybe that you run across during COVID? And then you can feel free to broaden that for other issues that you may see around the year.
How about I weave it in together? So,
please.
So, a great acronym for everybody out there to really keep in mind is PEACE, P-E-A-C-E. You will actually even see some judges write it out as they're, judging a case. And the P stands for parenting issues. The E stands for equitable distribution. The A stands for alimony. The C stands for child support. And the E is sort of that catch-all E, everything else. Obviously, if you don't have minor children and you don't have the P, the parenting issues, and the C, but let's say that you do, that's a great acronym. It's a great acronym because it covers all the issues, but also that's the order that the issues need to be decided by the judge, because the equitable distribution is impacted by first the parenting issues. Alimony gets impacted by equitable distribution, and so on and so forth. That's why we decide them. So let's start with the P, parenting issues. What I have seen in Florida and what COVID has introduced is what happens when the parents aren't in agreement. We don't have a playbook for the COVID issues. When one parent is very COVID safe and very COVID protective, and the other parent might be a little bit looser with the rules, how does a court decide that issue? You know, what during the pandemic, if one parent doesn't even want the children going back and forth between houses because of possible exposure, and they just want the child to remain with them. These are some of the impacts that we saw, and there was no playbook for the judges because we were in uncharted territory. Speaking of parenting issues, we are not a custody state. We hear all the time, and I'm sure Shaina hears it all the time, I want custody of my children, or I would like custody. Florida abolished custody more than a decade ago. We were the very first state in the United States to do that. There's parents, and nobody has a superior title. We did away with titles. Every case ends with a parenting plan. There's parental responsibility, which is decision-making for the children. And then there's the time sharing schedule, how the parties will share time with the children. And that's the parenting issues aspect. Go ahead.
No, I would, and we'll loop back around to some questions I may have on custody in a few minutes, but I can totally see some of the challenges of COVID. Like, I'm even aware of family situations where both parents aren't on the same page. When does the child return to face-to-face education, or does the child stay in remote education? And then throwing attorneys and a judge in the middle of that to help determine that, I'm sure, brings some unique challenges.
Absolutely. You know, there have been such unique challenges with face-to-face versus online. You know, should a court be making that? How do you break that tie? What if a parent there were cases that were actually being litigated where a parent was a doctor and was seeing patients, and should a parent who's out there seeing patients, seeing possible COVID patients, now be coming home to a child, and was that an interference with their parenting rights? These were all of these uncharted issues, and there was no playbook. And you would hope that the parents would be able to come to an agreement, but if they couldn't, then they were having to go to a judge. And sometimes the judges just didn't know, what to do.
And I can imagine, if the word we're hearing from the CDC is accurate, that potentially as early as next week, vaccines for children 12 and above will be okayed. I could imagine there would be parents in the middle of divorce proceedings that may have very different views on vaccination for their children, and that those could end up before a judge.
And I was having that decision, that conversation with somebody, and I will tell you this. So vaccines are not an uncommon issue, meaning, this is not the first vaccine that came out. And there are divorces that happen where the parents disagree on vaccines. Typically, what the court will do is they will defer to what the parties have been doing to that point. So if the parties have had a scheduled vaccine schedule, and then all of a sudden they're getting divorced and one party doesn't want to do it, maybe the court will say you're on schedule. But here's a whole new issue. I don't know what the court's going to do, but I'm not so sure that the court has the authority to decide that COVID, that COVID issue. Or Like, for example, when one party wants hormone treatment for a child, we've heard of that, human growth hormone for a child. Absent real medical testimony from a doctor that says the child needs it, they're going to treat that as cosmetic. They're going to treat that as a nose job. They're going to treat that as something else. That's what the courts do, unless it's medically necessary. When it comes to COVID vaccine, I'm just thinking that the court might not make that decision absent a doctor saying it's somehow medically necessary for the child. Because, you have personal feelings and then you've got legal feelings.
And if I can jump in, David, I know that one of the hotly debated things sometime in a divorce case is about parental responsibility. And sometimes the parties are vying for who can have decision-making authority about non-emergency healthcare, which would cover, I think everything you brought up, that if one parent did have decision-making authority about those issues, they ultimately would, whenever they disagree, that person would be able to make the final say. Sorry to jump in on your section, but that's what I would try to do maybe.
Right, it's a great point, which is, Shaina brings this up, which I had said that the parenting plan has two aspects. One is decision-making and one is time sharing. When it comes to decision-making, the statutory default, it says the default is shared parenting, shared parental responsibility. Unlike parental responsibility, there is no default time sharing schedule. So, if the parties have shared parental responsibility, the court is empowered to provide what's called ultimate decision-making over a limited area, but they're only able to do that when the parties are either gridlocked or one party is just not making the best interest decision for the child. If it's just a COVID issue, I'm not, it's going to be interesting to see if the court's willing to give that tie-breaking authority to one parent.
So for now,
and as it relates to domestic violence, Zoom makes it weird. So as it relates to domestic violence, there is in the statute, it says if one of the parties is the victim of domestic violence, it does give them a presumption of decision-making authority. So I guess that's how we tie it into domestic violence.
Unpack that for me. Does that mean that if they're the survivor of domestic violence, they have more weight to make legal decisions?
It means that they are presumed that they can have decision-making authority. Essentially, the law understands that if you're the victim of domestic violence, you might not feel comfortable voicing your concerns to your abuser. So that's why the law presumes that you should be able to have the final say so that you don't have to stand up to your abuser. However, it's just a presumption. And as David's over there, he knows all presumptions can be overcome. So it's not a slam dunk, but it certainly pushes the scale in one direction, and then the other party has to overcome it. Maybe by saying, but I've always been the one to make the medical decisions, but she's a drug addict, so she shouldn't. So again, presumptions can be overcome, but it is one reason why having a domestic violence injunction or a criminal case, or even if you don't have an injunction or a criminal case, you can present evidence within your dissolution of marriage case about domestic violence in order to go toward that factor. Again, though, as David said, it is the default for shared parental responsibility. So courts don't want to do that if they don't have to, because Florida does understand that they're both the parents. So, but it is an interesting point to bring up when we're talking about domestic violence and family court and the crossover.
Yeah, let's take a few minutes then. We're gonna, like I said, we're gonna kind of weave back and forth between you two. So I want to kind of turn our attention back, if we may, for a few minutes to the conversation we were having about injunctions. Seems like this is a good time to kind of turn our attention back there. So you were kind of explaining to me the options if I were living with a family member. What type of injunction should I apply for if my abuser is someone I know, but is not related to me, and I've never had a dating or intimate relationship with this person? What are my options?
So it's going to depend on how they're abusing you. If there's only been one incident of violence, I'm not sure that there actually is an injunction that's appropriate for you. In that situation, sometimes it's that you call the police in order for a criminal case to exist. Injunctions are an interesting concept, right? Because it's making behavior illegal that otherwise would be legal, right? It's saying just coming around me is illegal. So that's why in domestic situations, why it's the definition is more broad, because you're gonna have to be around me all the time. But when it's someone you just know, but you're not necessarily, I guess the danger isn't as high that they're going to interact with you all the time. So I guess the understanding being that a criminal case would be enough. And if you do have a criminal case, you'd get a no contact order through a criminal case, ordering that person to stay away from you if they was found to be battery. So I think if there's only one incident, I'm not sure that any of the injunctions apply to you, because again, not dating violence, it wouldn't be stalking because it's one incident. Repeat violence obviously means there has to be more than one. So unless it's a sexual violence situation, which obviously has special definitions as far as what qualifies as sexual violence. So unfortunately, in that situation, I'm not sure an injunction would be, there's any injunction for you to apply for.
Did you say that the first step would be calling the police to establish that criminal case? Is that first step?
For sure. We always will tell people, that sometimes they'll call our office and, if it's an emergency, if you're in danger, always the first step is to call 911, to call police. Now, a lot of people have their reasons for why they might not want to call the police. A lot of people in their communities, they're told you don't call police on family or whatever the understanding may be. So I never try to give a one size fits all solution for people. But that if it's just one incident with another person, I don't know if there's an injunction that you would petition for that you would get granted. It's possible they'd give you an order setting, which would be giving you a hearing, but without actually issuing a temporary injunction. Or it's possible they would just give you an order denying, saying that what you've put in your petition doesn't rise to the level for the issuance of a temporary.
Okay, so I'm going to dig into a few things that you mentioned in passing to we'll unpack those a little bit together. So you talked about this whole sort of level of difficulty to do the stalking injunction,
Right.
and that's a really challenging one, but you've referenced that it's something may be the option for some people. So if, I believe someone is stalking me, but hasn't been physically violent with me, what are my options? How do I establish that? What do I do?
So I think that it's, you can always call your local police department to have them at least write up some reports. I'll just tell you right now, they're not going to arrest someone just based on, one or two incidents or anything like that, especially if that person's not admitting to it. But it's good to have a report of it just in case. It also helps you keep track of the dates of everything. I would say keep track of dates, keep yourself safe, but make sure you have as clear of a narrative as possible that's almost showing how it's escalating in the steps and why, okay, one of these things on their own, not a big deal, but when you add them all up, it shows that it's a course of conduct that they're engaged in at me and that there's no purpose other than to make me upset, basically. So that's kind of how you have to establish it. So I know that it's difficult to prove, but sometimes that is what is appropriate.
Absolutely. And it's a scary situation if you're in there, because as you say, you're wanting to establish that legal justification for this is escalating and this is for the purpose of intimidating me. So I know that's scary. I know also in your previous statement, you kind of did a little sidebar specifically around sexual violence and saying that has kind of some different definitions and some different levels. So if I am a victim of sexual violence, but I haven't dated this person, I'm not related to my abuser, what are my steps? What am I looking at? What am I wanting to do?
So unfortunately, the injunction for sexual violence is the only one that actually requires that you're cooperating with police. It says that right in the instructions for it. I'm not sure if that's because sexual violence crimes inherently are going to be behind closed doors. And so I'm not sure the reasoning behind that. But it does require that you're cooperating with police. And
what's that mean?
Right. What does that
What's that mean that I'm cooperating with the police?
It means that you have to have filed a police report, that you have to have called the police to report it, and that you're giving a statement. It could mean that you're willing to consent to, it's called a rape kit, where they'll test, swab you and things like that. I guess it could depend on when you report it. Obviously if you're late reporting, then that's not a possibility. So it's unfortunate that that is a requirement of it. The other, now for all of these injunctions, including sexual violence, you can also petition for them on behalf of a minor child. If it's the child that's actually the victim, as opposed to the adult that's the one petitioning. So and obviously that the definitions of sexual violence are, sexual battery, lewd and lascivious act, enticing a minor. But again, most people, if you do have an injunction that's for a child also, which the sexual violence ones may be, you will have to file a motion to admit child victim hearsay statements prior to any final hearing. Because as you obviously understand, the court's not usually going to want a child to testify if they don't have to. So you generally, if it is about a child, they're going to want to have a hearing before the final hearing to determine if the statement was made under trustworthy circumstances and therefore should be admitted. Like, for example, if the kid told a counselor at school, or did they tell like someone from F.A.C.E.S, or did they just tell their mom? I guess those are the types of things that would get determined at a hearing, whether or not the statement should be admitted based on how it was received.
So this kind of standard of, if I can use that word, I don't know if that's the legal word, but I'll use it for now because I'm not a lawyer, so I don't have to. But this idea of being cooperative with police, I'm a layperson, but I hear the statement like statute of limitations. And you mentioned kind of this idea of if the rape kit is used or not. But I mean, I think especially right now during this pandemic, I can imagine there may be some major lag time, either if I am the survivor or my child is the survivor, between the incident happening and reporting. Is there a statute of limitations on this thing? Like, what is that time period under which this would need to happen for me to be viewed as cooperating with the police?
So what it says in the instructions is that you have to have reported it to a law enforcement agency and be cooperating if there is in a criminal proceeding, if there is one. Doesn't matter whether the criminal charges have been filed, reduced, or dismissed. So I guess what that says is you just have to have reported it to an agency. That doesn't mean that they have to choose to file charges based on it. It just means that if they choose to file charges based on it, that you continue to, show up for hearings or depositions or whatever is required in execution.
But there could be a gap of time between when the incident occurred and when I reported it for myself or my child.
There's nothing that says there can't be a gap. Now, is that going to be something that a judge personally takes into consideration? Certainly, that might be something that a judge takes into consideration. There is a specific time that you actually can apply for the sexual violence injunction. If the respondent, which is the abuser, was sent to prison for committing one of the sexual violence crimes and against you or your minor child, and they're getting out of prison within 90 days of your petition, you can apply for it just based on that. So that's clearly a delay on when it happened, but they've been in custody, so you haven't been worried about an injunction, but now they're getting out. So now your fear has reinvigorated. So that's definitely an example where there can be lag time in between. As far as reporting to police, again, that's going to be up to each individual judge, whether that goes into their determination of whether or not they believe it's happened based on the delay. That goes to weight, not necessarily admissibility.
Okay. And you said the term respondent, is that me or
the response?
So
when
abuser?
The respondent is the alleged abuser. The petitioner is the alleged victim. The petitioner is the one that petitions for an injunction against a respondent. Now, it's possible the respondent sometimes counter petitions, and so then you can be a petitioner and a counter respondent, and you can be a respondent and a counter petitioner. You can be both.
And since you brought up children, let's talk about that. So, if I have children and I have an injunction for protection for myself, does that provide any protection for my child?
So it can provide some protection for your child, depending on if you're married or not. If you're not married and there's no order of paternity, then a judge is not going to be able to order time sharing for the other party, because under the state, if you are the mother, that is, because in the state of Florida, the mother is viewed as the natural guardian, meaning that if there's no order of paternity and you're not married, that means that you're considered to have all of the rights to the child.
What if
So
you're two fathers?
that's a good point. So I would think in that situation, I'm not sure if there is a natural guardian. So in that situation, if you're two fathers and you're married, then both of you have paternity. So if you get married right around the time of the birth, or the birth happens after you guys are married, you guys are would both be the assumed father, assuming through the adoption. I guess it kind of depends on how you, that individual family circumstance. But generally, if you're two fathers, most of the time that's going to be in a situation where you're both married. There's some situation where you clearly both have paternity. Where now an injunction, when you get a temporary injunction, on the plus side, it will give you exclusive time sharing 100% with the child for at least the 2 weeks up until the final hearing. And that's really just to make sure that nothing happens in those 2 weeks before a judge gets a chance to hear from everybody and see what needs to be done to keep people safe. But then at that final hearing, if the parties are married or like you said, paternity is established, then the judge can order a time sharing schedule between the parties. Now, if the petitioner is alleging that the child was present for some of the abuse, even if the child wasn't actually the victim, it would still be appropriate for you to ask for maybe supervised time sharing. You could ask for batterers intervention prevention. You could ask for a parenting course. Some judges will order it even if you don't ask for it, because some judges will hear the circumstances and say, I'm concerned. And so I think you guys both need to go to co-parenting because you guys are both arguing in front of the child. So all of those things can happen. So it does provide some level of protection for those 2 weeks, whether you're married or not, whether paternity is established or not. And if there's no paternity or marriage, then you will continue to have time sharing until that person files a separate proceeding in order to get paternity.
So some of this stuff is fascinating. I mean, it's all fascinating, but some of this stuff is really fascinating because I never knew until this conversation, this sort of presumption of the mother being caregiver guardian in Florida law. So what happens if it's a pair of women that are the parents? How do they handle that presumption if both parents are moms?
So I haven't personally encountered the situation, but what I would imagine is that it would probably, if neither of them gave birth to the child, then I would think they would have equal footing. But if one is the one that gave birth, it's possible. But again, I haven't actually had one of these cases, and the statute just says that the mother is the natural guardian. Again, if it's a situation where there's two mothers, I would assume that there was an official adoption. It depends on your situation. You know, one might carry and then the other mother adopts it. In that situation, I don't think either party has any more footing than the other. So I think it kind of depends on your unique circumstances. But I do advise, for men, if you're wanting to make sure, you can get an order of paternity, before you end up in one of these situations. But
and I think this is a good time, probably, like, David, please unmute and join the conversation as well, since we're talking about children. And that was some of the questions I was going to head to when we're looking at, family dissolution and divorce here, because I do think, at a personal level, and, I will self-disclose here that I'm not looking to get divorced right now. And I don't believe that my partner is either. But, my partner and I have been together for 20 years. We are not legally married. We do have an adopted child. Both of our names are on the birth certificate of the child. Both of us are the adoptive parents, but we're not married. And so in that situation, do we share how paternity looks in these kind of situations?
Well, so you both went through an adoption proceeding, is that correct?
Absolutely.
So then if you both have adopted and you both gone through the adoption proceeding, then you both are considered the legally recognized parent, okay? The issue that we have when it comes to a paternity is where there has not been an adoption proceeding, where there has been a child born out of wedlock, there has not been a formal adoption, and so therefore it has to be legally established in order for a parent to have rights. In fact, so often, and I'm sure Shaina knows this in her practice as well, I will have somebody in my office and they're floored they are floored that despite the fact that they are on the birth certificate, they do not have any, quote, legal rights to the child. So that's what distinguishes you from that situation. You have gone through the formal adoption proceeding. Also know that a child born during the marriage is presumed to be the child of the marriage. And so what's interesting about that point is we've seen that play out in heterosexual couples for decades in Florida, And what I mean by that is man and woman are married. Woman has a child. It does not matter in Florida, that is the legal child of the man. Even if he's in prison, even if he's overseas, even if it's clear that the child is a different race than the father, that is still the legal child. What we don't know now, because same-sex marriage is such a new concept, I mean, we know that it's only been legal for a handful of years, is we're going to start to see some other issues. By way of example, a man doesn't really have a child, naturally, but a woman does. What I have not seen yet is, imagine a same-sex couple, two women, and the woman gives birth naturally. Is that child the legal child of the wife, of the non-birth parent?
I would argue yes, because I think the law is written that we don't want children to go without having both parents. Is generally the child shouldn't be the one that suffers. You don't get to just leave and be like, well, I don't want to be a parent anymore.
Right. I agree, and I think we've seen the law say that you're supposed to apply the law, the same, and I think that that's how it will be applied. But we will see issues like this. Some other, I think, issues that we will see, and I know you didn't exactly ask this, but I do want to kind of get to it, is same-sex marriage has only been legal for a handful of years. So how will we define the length of marriage in certain situations where the parties have been together for 20 years?
Right.
But technically, legally, they've only been married for 5, right? Or whenever you legally got married. That can impact alimony, because that can impact equitable distribution, because equitable distribution defines marital assets and liabilities from the date of marriage to the date of filing. There have been, cases where parties have, go ahead.
David, let me just put a pause here so that term-wise, our audience may be all on the same page. So can you just redefine there, when we say equitable distribution and people say that Florida is an equitable distribution state, what does that mean?
That's a great question. Okay. So some states are what's called community property states. Some states are mixed property states. Some states are equitable distribution states. Florida is what is called an equitable distribution state. What that means is that marital assets and marital liabilities are to be divided between the parties equitably. Equitably does not automatically mean equally. We begin with the premise, not a presumption, but the premise of an equal distribution, and then parties can argue for what's called an unequal distribution. So we first begin with what is a marital asset and liability, and I kind of hinted at it earlier. Simple. Everything that the parties acquire during the marriage, regardless of whose name it is in, is marital, subject to equitable distribution. The only exception is if somebody acquired something by way of gift from outside of the marriage or inheritance, and it's kept separate. Other than that, everything is presumed to be marital. And then once we identify everything and we classify it as marital or non-marital, we value it and then we distribute. And the whole equitable distribution is we distribute equitably. We begin with the premise of an equal distribution, but that can be changed and that can be altered based upon some unequal distribution factors.
Such as dissipation of the assets, like you were talking about earlier.
Correct.
Right.
Correct. So by way of example, if someone has $50,000 bank account and they go to Vegas and they have a wild time and they gamble away $50,000, the other party may be entitled to a credit for $25,000. Why is it 25 and not 50? Because half of it was one party and half of it was the other. If you take $50,000 and you buy your girlfriend or your boyfriend a expensive Rolex watch, well, your spouse is going to be entitled to a 50% credit because you dissipated assets in order to buy your significant other that watch.
And I think I heard you alluding to that there may be some new interesting aspects here in Florida of like, hi, my partner and I have been together 20 years, for instance, but others may be together 25, 30 years, but only have had the option of getting married for the last few years. And
That's
so
correct.
some of those assets, a home in both their names, a title in both their names, property, may long predate the actual marriage date. And so how are those addressed or handled in a situation where the relationship and the assets may long predate the ability to get legally married here in Florida?
So it's still a developing law. It's still unfolding. The easy answer is, do you qualify? See, Florida does not have common law marriage. So let me begin there. Florida does not have common law marriage. So whether you are a same-sex couple or a heterosexual couple, there is no way to be common law married in Florida. But Florida will recognize another state's common law marriage. So by way of example, so if you and your partner were living somewhere else and you qualified for a common law marriage in that state, Florida will recognize that. So if you are a same-sex partner and you qualified or had a civil union, that may be one way. But let's say you've lived in Florida all this time. There are other equitable remedies that people are arguing for right now. I'll give you an example. There have been cases where parties have thought they were married, and it turns out that they were not. So I'll give you an example. Parties are married March 3rd, 1995. Unknown to the both of them, the husband's final judgment of dissolution of marriage was not entered until March 8th of 1995 from his first wife, 5 days after those parties were married. That means that their marriage is void because you can't have two marriages at the same time. So they have lived as husband and wife all this time since 1995, thinking that they were legally married, but because technically on the day that they were married, the husband was technically still married, they have a void marriage. There are equitable remedies that the court can award and basically treat it as if it was a marriage and do equitable distribution. It's a different form of relief, but you can do that. I've seen parties start to argue, but the question is this: did the parties just live together as boyfriend and boyfriend or girlfriend and girlfriend? If a civil union was available to them, did they avail themselves to it? These are questions that the courts are answering because let's just say that, and I hate to use it, but a heterosexual couple who had marriage available to them doesn't get married. They just live together as boyfriend and girlfriend, right? There are no rights that are ignored in a relationship like that. When it comes to a same-sex couple, the argument's going to be Well, we didn't have the right to marry, so we couldn't have gotten married. But if a civil union or somehow a civil was available to them and they didn't choose to do that, I believe the courts are going to treat that situation similarly.
I think, yeah, you can try to make an argument. Maybe if you bought a house and put both your names on the deed, even though you weren't actually married, you could try to argue. But like David said, it's developing.
Thank you all for your insight on that. I'm going to turn back to injunctions in a second, but let me follow up with a couple more questions in this family law area. So in Florida, how's alimony handled?
Okay, so the way alimony is handled in Florida is there are various types of alimony, which I will go into in a second. But the first thing that Florida does is they say alimony, the analysis of alimony begins with need and ability to pay. One party has to prove that they have a need, and they have to prove that the other party has an ability to pay. That's where we begin, regardless of the length of marriage. If one party has the need for alimony and the other has the ability to pay, then Florida gets into types and gets into amount and gets into length. The different types of alimony, number one is temporary alimony. Doesn't matter if your marriage is a day, a month, a year, or 50 years. There is something called temporary alimony, and that is alimony paid during the pendency of the divorce. The purpose of temporary alimony is to not allow one spouse to cut off the other spouse simply because a divorce is filed. Florida believes that the financial status quo should be maintained during the pendency of the divorce. Outside of temporary alimony, the other forms of alimony are durational, permanent, bridge the gap, and rehabilitative. So bridge the gap alimony is alimony that's supposed to be for a short term, can't be any longer than 2 years. And it is to bridge the gap between married life and single life. Rehabilitative alimony is specific to a party who maybe doesn't have an education or doesn't have a work history or work skills, and it is to rehabilitate them to get into the workforce. So that has to be pursuant to a very specific rehabilitative plan. Permanent alimony is alimony that goes until the death of one party, or until the remarriage of the recipient, but it is always modifiable. And then durational alimony is alimony that is awarded for a certain duration of time, and it can't exceed the length of the marriage. Those are the types. Florida defines a short-term marriage as 0 to 7 years, a marriage of 7 to 17 years as a moderate length marriage, and a marriage of 17 years or longer as a long-term marriage. Typically in a 0 to 7 year marriage, the most common type of alimony would be bridge the gap. In a long-term marriage, the most common type would be permanent. And in a moderate length marriage, you'll often find durational alimony to be the most common type.
And so, David, is this where, I think we were just talking about, there may be arguments for same-sex couples in looking at that year, because legally, all of us are going to fit into that first category, though situationally, there may be many couples that are in that second or third category. And that's where it's going to kind of bring up some of these issues of, was civil union available to you? Is this where we dig into some of those issues? Because it seems like it would be really relevant which of those three I'm going to fit in if I have a 30-year relationship and yet I've only been able to be legally married for 5.
So there's not a lot of judicial discretion when it comes to the alimony statute. The alimony statute is very, very specific. That length of marriage is how it's defined. So now, does that mean that Florida will be more, I guess, either liberal or allow those types of arguments? It's a developing law. It really is a developing law right now. And there's cases that are going up on appeal, and there's cases of first impression. And so it's a really developing topic.
Thanks, David. Let me put a pin in this, because we got into a lot of these sort of marriage dissolution issues, but I want to come back to, if we can, back to Shaina, because we were looking at some of the issues of injunctions specifically things that protect me, do they protect my child? And I think that that's kind of, we ended up in some other discussions about sort of marriage dissolution may happen with some of the children. So if I have an injunction, can I ask for precautions to be taken before my alleged abuser can see the child or can have a time sharing experience or anything? Like what rights, what options do I have?
So if the judge is talking about putting forth a time sharing schedule because the parties are married or there's been paternities already established, certain things that you can ask for is you can ask for certain precautions to be taken during exchanges. So we often will recommend doing the exchanges maybe at a police station or inside a Walgreens or CVS at customer service where there's cameras or witnesses, in order to hopefully deter the other person from behaving badly. And if they unfortunately do behave badly, to have it on video in order to show in a either domestic violence case or in a dissolution of marriage case, as far as a reasoning, maybe for decision-making authority or some of the other things we were talking about before. Other things you can ask for, again, if the child witnessed the abuse, you can ask for a parenting course or for supervised time sharing. Often the courts will recommend that maybe supervised time sharing at a place called F.A.C.E.S. That's an acronym. Don't make me spell it out right now. But it's a place where they'll be able to supervise time sharing. They also have people sometimes that are actually trained to like mental health training, and they're actual active supervisors versus like there's just somebody there. So they have different levels in terms of what is appropriate in your circumstance. Now, I think that those things are more likely to be ordered when it's actually an injunction on behalf of the child, as opposed to the child just witnessing the abuse, but it depends what they witnessed, But what I do have to tell my clients, which David, I'm sure, has to tell his, is that in Florida, even if the father or the mother abuses the other parent, that parent still has rights to time sharing. That in and of itself doesn't mean you're going to get, as David talked about, full custody. Many people have the impression that, oh, well, because I was hit, I get full custody of the kid. That's not how the state of Florida looks at it. And so what it could affect it if the child witnessed it, again, parenting courses, supervised time sharing, but that's only going to be for a temporary basis. In order to terminate someone's parental rights, there's going to have to be a dependency proceeding, and that person will get a right to an attorney if somebody is looking to terminate the parental rights. The state of Florida can't take away your rights to your child without giving you the opportunity to be heard. So while there are protections and the judges can order that it's supervised or that they take parenting courses, the only way to get sole parental responsibility or sole time sharing, the child is going to have to be in danger of abuse or neglect, not just the parent. And this does not matter whether I personally agree with that or not. That is what the law is.
I hear you, Shaina. And that it kind of raises the question broader, not just for parents, but anyone that is sort of in an injunction situation. If an injunction is granted for me, what can I ask the court to order my alleged abuser, the respondent, the person that's, exacted violence on me? What can I ask the court for that person to do or not do? And I think in terms of financial support, firearms, substance abuse treatment, mental health treatment, divorce, kids, like what are the parameters under which I can ask stuff to do or not do?
Okay. So if the injunction is granted, they are going to have to surrender their firearms, the opposing party. Now, does that mean that the police necessarily searches the whole house and makes sure that they're all gone? Not necessarily. So you may have to tell the police, hey, I know that they have additional firearms when that's happening. So that is a part of an injunction. So additionally, you can ask for batterers intervention prevention if you are in a domestic relationship with that person. And that's what we would recommend as opposed to anger management if you're in a domestic relationship with that person. Batterers intervention is specifically for people that abuse their partner. People that abuse their partner don't have the same issues that people with anger management issues have, because it's more about power and control than it is about impulse, which is what anger management is about. And so that's why we recommend batterers intervention prevention when it is that type of violence. You can also ask for a mental health evaluation and recommended treatment, a substance abuse evaluation and recommended treatment. It's ultimately going to be up to the judge whether or not to grant those things. Like I said, sometimes you don't ask for them and the judge does it anyway. Sometimes you ask for them and the judge says, no, I don't think that that's rise to the level. If the judge does choose to grant your injunction, what it means is that person has to stay 500 feet away from you wherever you are, and they have to stay 100 feet away from your car wherever your car is. Now, you can also add some additional addresses into the final judgment of injunction, like your specific home address or your work address, or maybe where your kid goes to school. But what we do recommend is that if your abuser doesn't already know those addresses, probably don't include them in the final judgment. You don't want to tell them about these places that you're frequenting. And so what the judge will also ask you, if they're granting your injunction, they'll ask you for how long. So the way that to ask if you want it to be permanent, you say until further order of court, which is just basically means it's going to stay in place until somebody moves to dissolve it or modify it in some way. So that's the way to say permanent. Now you can ask for it to be permanent. And again, the judge can grant that request, or the judge can say, you know, based on the fact that you guys have really only known each other a couple of years, and there's only really been one incident, I'm only going to grant it for a year. That's possible. Again, that's ultimately up to the judge how long to grant it for. I think that covers, you know, financial support. You asked about that. So if it is a domestic violence injunction, then there is a portion in your petition where you can ask for temporary support. If it's one of the other types of injunctions we talked about, there isn't a section in the petition to ask for that, because I guess it's naturally understood that why would they have to support you if you're not living in a household with them? So you can ask for temporary support. It's ultimately going to be up to the judge, and the judge is going to determine it based on the same things David was talking about: need and ability to pay. So do you need it, and can the other party pay it? And something that's going to come into play is the fact that usually the injunction gave the petitioner exclusive use and possession of the home. So the respondent often has to find a new place to live. They may or may not have a couch that they can crash on. They might now be paying for a hotel room, paying for another place to live. And so that can affect their ability to pay any alimony to the other party. So not alimony, temporary support. Again, only temporary, modifiable through any accompanying divorce case or anything like that. You can ask for it, but the judges do end up focusing most of the time on the domestic violence rather than financial issues, because that is why you're there. If there is a family case that's filed after the petition is filed, or that already exists before the petition is filed, that injunction is going to be heard by the same judge that's overhearing the divorce or the paternity. The idea being that one judge should hear about all the issues because they are somewhat related, rather than I told this judge, now I have to go tell another judge, but the other judge is the one that heard the good evidence. And so that's why there is the understanding that if there's a family case, the same judge will hear both.
Okay, that makes sense. One of the things you were mentioning earlier brought up the question in my mind: safety plan. It's a term we hear a lot. It's an idea we hear a lot. Talk to me about victims petitioning for justice and their need for a safety plan. Why do we need that?
So the reason for a safety plan is because oftentimes you may or may not be able to support yourself on your own, depending on whatever your situation is with your partner. And although an injunction may temporarily give you exclusive use of the home, it's just temporary if the other party is the one that truly has the superior right to the home. They can file an unlawful detainer or an eviction action, and that can supersede whatever the injunction may say.
What's an unlawful detainer?
Thank you for asking. So an unlawful detainer it's basically an eviction when you're not really a landlord. It's when someone is, you're the owner of the house, someone's living there, there's no written lease or anything, but you want them out. They don't have any rights to be there. So it's basically like an individual's eviction rather than a landlord's eviction. So while a temporary injunction might give you exclusive use and possession of the home for now, if that other party is the one that's the rightful owner of that home, you guys aren't married, whatever, so you don't have a claim to it, you might need to start figuring out a place for you to work and live on your own if that's what you're planning to do. Again, even though you can ask for alimony in a divorce case, David will tell you sometimes it can take weeks before you actually get a hearing on your motion for support in a family case. So you might have weeks before you ever see anything, if you ever see anything. So it's really important to, like I said earlier, so women in distress, No More Tears, Jewish Goodman Family Services. There's also Family Success will sometimes offer rental assistance if you're able to show I'm going to be able to pay the next month, but I just need help this month. So again, it depends on what your level of need is. Whether you're working or not working, you may need help getting a job. So that's the reason why safety planning is so important. Again, an injunction at the end of the day is just a piece of paper. And so it's not going to necessarily stop the other person from their behavior. And so that's why it's important to make sure that you're safe. Because, you know, it's good to keep your injunction with you, copies of it in safe places in case you do see your abuser somewhere. Call the police so you can show them the final judgment of injunction. But make sure that you stay safe. Don't start running after them to take a video of them to prove that they were there. Of course, you have to be safe. But those are the reasons why a safety plan is really very important, especially if you're completely dependent on this other person. You're going to have a plan for what to do, you know, after those 2 weeks of that temporary injunction. It's only 2 weeks, you know, and then things can change, whether that final is granted, or even if it's granted, maybe they give the other person possession of the home, even if they grant your injunction, but they say, but it's my house. They're like, oh, well, okay, I grant the injunction, but you have to move. So it's important to prepare.
There is wisdom in that warning. So I'll go back before the judge 2 weeks later. Is that how that works?
When you petition for an injunction, if a temporary is granted, generally the hearing is in about 2 weeks. Obviously that varies, but it's about 2 weeks later is how long the temporary injunction generally is for until you get to go before a judge.
Thanks, Shaina. And you did mention that whole issue of support. David, let me pull you back into this since we were kind of referencing over to some of these issues that are going to be addressed when it comes to alimony or child support. In these sort of situations of a divorce, how is child support determined here in Florida?
So as we've talked about that acronym PEACE, P-E-A-C-E, there's a reasoning behind it. So let's think about it. The P is the parenting issues. The E, we decide the E, which is equitable distribution. And one of the things we talked about, which is alimony is based upon need and inability to pay. And one of those things that we talked about need is who, you know, is somebody going to be living in the marital residence? Is it affordable? What's the cost? That's part of the need. You know, other things that we talk about need are, you know, are you receiving assets from the divorce that are kicking off income? There's a reason that we do these things in order. So now we come to child support. Child support is not the right of a parent. It is actually a right of the child, and it cannot be waived in Florida. And courts take it very seriously. And we have something in Florida that are called child support guidelines, worksheets, or child support guidelines. There is a statute. It is 61.30, and it provides you with how the court determines child support that's going to be paid. And what we do is we base it upon the respective incomes of the parties. That's why you have to do the alimony before the child support, because it is net income. So if somebody is paying alimony, their net income is lower. If somebody is receiving alimony, their net income is higher. So it goes into the guidelines. But what's the other thing that goes into the guidelines? The time sharing schedule. Once you cross 20% of overnights, the more time sharing you have, the less child support you pay. And the thought process and the theory behind it, that's called the gross up method, is if the child is with a parent more, and that's overnights.
You said the gross up? What was that word?
It's called the gross up method. Once you go past 20% of the overnights, the child support number starts to go down for the one that's going to be the payor, because the child or children are with them more. And so that's why we have to do the parenting issues first, because we need to know what that time sharing schedule is. So we stick into it, the net incomes of the parties. We stick into it, the time sharing schedule. Then there's two other things that we look at. One, health insurance. Is one of the parties carrying health insurance? Because if they, for the child, or children, if they do, they get a credit. And the other is daycare or aftercare, sort of those expenses. So they all go into the child support formula, and it spits out a number, and that is the presumptively correct number that a party should be paying for. And what's important is both parties' incomes go in, because both parties are expected to provide support for the child. That's how child support is handled.
Thank you, David. I feel like I'm learning so much from the two of you. I'm so grateful for you all spending the time with us tonight, kind of helping put all these resources into one place.
Exciting stuff. She gets the exciting stuff. I get the technical stuff.
I gotta tell you, it is all, I mean, all of this is really heavy, right? I mean, like if you're watching this, if you're experiencing this, like these are not positive emotions you're going through. Like this stuff is really, really heavy, but it's so important for those in our community that are experiencing this. It's really important to have these resources. So I want to say, one, to our audience that's watching, check out the comments, because Nick and Alicia, you know, as we post this, are going to put all the resources that have been talked about tonight, including Women in Distress, No More Tears, Goodman Jewish Family Services of Broward, Family Success, Coast to Coast Legal Aid, Legal Aid of Broward, David's Law Office, all of these will be down in there. But I do want to, just mindful of our time, Shaina and David, what I would like to do, if we can do a quick round of sort of getting down to some of the details of the how to, what to, give me some little tools so that I feel equipped leaving my time with you all. So one, where can I go to file a petition for an injunction for protection? So if I'm wanting one of those things to keep me safe from either domestic violence, intimate partner violence, my stalker, my repeat violence, sort of all the issues you talked about tonight, where do I go? How do I do that? Shaina.
Okay, you can go to the second floor of the Broward Central Courthouse, which is located at 201 Southeast 6th Street at room 2140 to petition for an injunction. Again, you got to wear some kind of mask, and you can tell the deputy or security guard that you're there to file a petition for injunction for protection. The operating hours are Monday through Friday from 8:30 a.m. to 5 p.m. You can also
Is face-to-face my only option?
So face-to-face is not your only option. If you qualify for our services, we might be able to help you. So if you apply for our services and you meet the requirements, we're able to represent you. We might be able to help you petition for the injunction online. But as you know, you're going to have to apply for our services. There could be a conflict. There could be whatever reason why we're not able to represent you. But that could be an option to you if you're having difficulty with transportation or anything like that. But unfortunately, I believe that there's the only way to do it is to go in person if you don't have someone to be able to assist you.
Thank you, Shaina.
There's also the West Satellite Courthouse at 100 North Pine Island Road, room 180 Plantation, if between 8 a.m.
Can you give that one more time?
Yeah, 100 North Pine Island Road, room 180, between 8 a.m. and 4 p.m. But the filings actually stop at 2 p.m. So really, you got to go between 8 and 2.
Okay, that makes sense. Mm-hmm. David, where do I go if I want to file for divorce?
Well, you would go to the courthouse, depending on what county you live in. For Broward, so like, for example, in Palm Beach, there are different courthouses. There's the South County Courthouse, there's the Main Courthouse, there's the North. In Broward, although there's many courthouses, there's only one that has family law judges, and that's the Central Courthouse. So that's 201 Southeast 6th Street. And it is the second floor, and that's also room 2140. You heard it from Shaina. And what they have is they actually have Supreme Court family law forms there that are available for purchase. Forms for divorce, for paternity, for custody visitation, for step-parent adoption, custody by extended family, and other various forms can be purchased between 8:30 a.m. and 3:30 p.m. Now that's if you're going to be self-represented. Obviously, there are other resources in town. There, of course, is, coast to coast legal aid. There's legal aid that you can go and see. You can go try to talk to an attorney. There are also attorneys out there that that specialize in sort of directing pro se or self-represented litigants and help them fill these forms out. And so there are different resources out there available.
So even if I'm not looking to seek for you to be my representation in court, I could still seek certain attorneys to help me fill these forms out. Is that what I'm hearing?
Yes, I mean, I don't personally do that, but I know.
No, I didn't mean you specifically.
Right? No. But actually, there are now some attorneys in town and in Broward County who have kind of focused or have kind of developed a niche, not their main part of practice, but sort of like a second part of the practice to help those who can't afford to hire representation. So there are various options out there.
And David, when you mentioned that there's these forms that are available in room, was it 2140? Did I get the right number since both of you were mentioning it? Like if they're available for purchase, and I recognize there's probably some kind of differentiation there, but like, what do we ballpark? Like, if I'm going down to look at these things, what do I need to have in my mind prepared that I need to bring with me to purchase these things?
Well, what's nice is that they have a self-help desk that will help guide you in what forms to fill out. So what you need to bring with you is just yourself. So like some of the basic questions are, do you have children? Do you not have children? Do you know where your spouse is? Because maybe you don't know where your spouse is. Maybe you've been separated for a long time. Do you have assets with your spouse? Do you not? That's the stuff. Other than that, you need your ID and maybe a form of payment if the forms are going to cost you money, because some of them you can download. Some of the forms are even available for free on floridacourts.org is another place that you can go and take a look at the Florida Supreme Court forms.
Thank you for that, David. Hey, Shaina, I just think, like, what do I do if I'm seeking to file a petition after hours or on the weekend? Like, I can imagine that may be my situation where, like, I need to do this and I can't, it's Friday evening and I can't wait till Monday morning. Like, what do I do?
Yeah, unfortunately, domestic violence situations don't limit themselves between Monday and Friday between 9 and 4. We obviously realize that. So thankfully, Women in Distress has a Broward County crisis line at 954-761-1133 that they can help determine whether you're eligible to file outside of the court's regular business hours. Again, Women in Distress, maybe they can set you up with someone that could help you with the filing or anything like that. So we do think that a good first step is to, maybe you're your advocate at your police department. If you filed a criminal case, your victim advocate might be able to help you out also.
Absolutely. Thank you for that really important, helpful information. So kind of back to our brass tacks details. So in either situation, and you two can tag team this, the court has now set an upcoming hearing. Are courthouses closed? Like, how does the judge hear my case right now?
It really depends on the county. So different counties have different rules. For domestic violence, I believe they are conducting them in person, or at least in Palm Beach they are. In Broward, are they conducting them in person or by Zoom? I think in person.
So
correct?
In Broward, they're still by Zoom, but we have reason to believe that they will be in person come the end of June. They are considered mission critical, which is why they have been going on through Zoom. We know that criminal misdemeanor cases have already started. So that's indicating that DV cases are soon. I think dissolution of marriage cases, because they have been operating on Zoom, they will probably continue on Zoom for a little longer, up to that judge's individual discretion, whether or not to make it be in person, depending on the issues, is the information I have.
That's right. The majority of stuff is being conducted by Zoom. Palm Beach went a little bit more liberal than Broward did. So what Palm Beach did was they went months ago, they said domestic violence will be in person. All other family law matters will be by Zoom. Then they gave discretion to the judge, and they said if it's a trial, the judge has discretion whether or not to do it in person. So that became, you know, a judge by judge and almost an issue by issue. Broward, as you heard from Shaina, did not do that, but now they are starting to be a little bit more flexible. So that's what's going on. But but most of the stuff still in both counties is being conducted by Zoom. In fact, yesterday and today, I did a 2-day trial completely by Zoom.
So let's talk about Zoom for a second in this situation. So attending a hearing. So I need to have computer access, Wi-Fi, or a phone with video capabilities in order to attend the hearing?
That's correct. Yes.
Which could be a challenge in some of these domestic violence or divorce situations, right? I mean, we've looked at some of the little challenges that we've discussed of who owns the house and who has access, and is this a safe place? And so how do I get this Zoom link? Like, is the court going to email me that? Like, how does that work?
So the Zoom link for an injunction on your paperwork where it's telling you when your hearing is will be included on your paperwork. Of course, that's not the most convenient way to enter it, having to type it out. You can also go on to the individual judge's courtroom procedures, which will have the link to they have the same Zoom link every day. So you just go into procedures and you follow it that way. While you probably are going to end up having video capabilities, you know, on the first hearing you have, you can try to dial in by phone, but most likely the judge is going to want to have to see your face. The judge has to take testimony. The judge has to judge your credibility, whether or not you're lying or telling the truth. And that's hard to do over Zoom. It's impossible to do over the phone. So that's why it is going to be necessary to maybe practice some days in advance. If you have a friend or a family member that's willing to help you out, great. You know, we do have some helpful tips about appearing via Zoom. Again, make sure you enter your name on there so the judge knows to let you in, because you don't want it to just say your phone number there, because the judge doesn't know that your phone number is you. So make sure your name is entered how it is on the legal documents. Not, you know, maybe on the documents it doesn't say your name, but that's how the proper name, but that's how you should enter on there so you get let into the courtroom. It's important, especially as a victim of domestic violence, make sure that you don't have any identifying things in your background. If your partner user doesn't already know where you've relocated to, make sure there's nothing behind you that would indicate it to them. People are more savvy than we give them credit for sometimes. So it's also, again, another important Zoom tip, as you guys have probably noticed throughout this, even when I'm not talking, you know, you can still see David, you can still see the other people. So it's important to not make faces, to not roll your eyes, to always look professional, because the judges do care about that sort of thing. They want to see that you're respectful of the procedure. The fact that you're sitting at your home should not change how professional you are being in court. It does not matter that you're sitting in your living room. You are still in court.
I had one thing.
Did you see me rolling my eyes at you, Shaina?
That's why I brought it up.
You saw me rolling my eyes at you. Okay, David, go ahead.
I had something that's really important that really needs to be said for people out there in the Zoom world. Prior to COVID, if there was a hearing, domestic violence or otherwise, how was that handled? You went down to the courthouse. The other side went down to the courthouse. Who wasn't there? Your children. Your children shouldn't be there. But now in the Zoom world, where you're home, it creates a whole new issue, which is your child or children could be listening, could be hearing. So that's something that really needs to be taken into consideration, that if you are going to participate in a Zoom hearing, make sure that your child or children are not within earshot, that cannot hear it. They shouldn't be hearing it. And so that's another challenge with Zoom that has presented itself.
That's a good point. You know, sometimes I tell my clients, you know, oh, if there's someone who can help you with your audio, let them help you. Because that's honestly the biggest problem people have connecting on Zoom is connecting to the audio. Even once they join it, they don't realize they have to click connect to computer audio or connect through Wi-Fi. But once your person in your house has successfully connected you, they should leave the room. You shouldn't be communicating with them during your hearing. Again, you should be looking at the court, looking off, moving things around, things you would not do if you were in a courtroom with the judge standing there. You shouldn't do.
Can I use my cat face if I'm the attorney?
Exactly. Yes. You should probably not use any filters that make you look like a cat, or anything of that nature. Dogs may be more acceptable.
Any other items, David or Shaina, specifically around measures I should take, safety measures I should take, things to keep in mind while attending the hearing via Zoom? I think these are helpful for folks.
It's interesting when it's interesting when you have parties that are still living in the same house who are doing a Zoom hearing, right? Mm-hmm. I've had that where the parties are in separate rooms, but are in a Zoom hearing together, and they're adversaries, right? So if we're in the courtroom and you have a contentious hearing and then it's done, you have the cooling off period, right? You have the period where you're sitting outside of the hearing. You have the period where you're driving home. You have the period where you're letting it digest. It's still dangerous. It's still, it still has that element, that danger element. That element is completely accelerated and completely heightened in Zoom times because there isn't that cooling down period. There isn't that, the hearing ended. Now I got to walk down the stairs, or I have to take the elevator. I have to drive, 25, 30 minutes, whatever it is from the courthouse, right? There's none of that.
They're in the next room.
They're in the next room, right? And so I'm not a big fan of any contentious hearing with my client being in the house with their spouse. I'm a big fan of them being somewhere else, or making sure their spouse is somewhere else for that hearing, because of that, if it's going to be a contentious hearing, because of that lack of cooling down otherwise. And unfortunately, when restrictions were higher than they are now, that wasn't always possible. And that was one of those dangers of COVID. So you asked that question, which is something to be aware of. I'm mindful of that. I'm mindful of parties who are still in the same house who are doing a Zoom hearing from the same house. But I'm sorry, Shaina, if I interrupted you.
No, please. This isn't related to Zoom because I already kind of touched on, make sure nothing identifying your background, but something to keep yourself safe is, even if you just have a temporary injunction and not a final, to if that prohibits them from going to your place of work or your child's school, to make sure they have copies of those in case that person shows up. Again, an injunction's a piece of paper. If you don't tell someone about it, they don't know that he's not allowed to be there or she's not allowed to be there, and then they may pick up your child.
So Shaina, when you say they know about it, you mean like, I need to take that to school. I need to make sure that my son's teacher or my son's principal or counselor knows that. And then like, I'm taking this to my place of work. Like I'm letting my boss know I have this, or letting someone at my work know this so that I'm safe there.
That's going to be, I guess, personally for you to decide what your level of comfort you need for safety. You know the abuser better than we do, in the sense that you know what they're capable of and what they're not capable of, what you think they do, what they wouldn't. So if you think that they're going to pick up the child from school, even though the order tells them they're not supposed to, then I think you should give it to the school so that they know if the person shows up not to release the kid to them. If you're worried at your place of work that personally, it depends on, if you think you're going to get fired from showing your boss, then no, don't show your boss if you need it for your livelihood. But if you're legitimately worried your partner is going to show up at your place of work, waiting for you outside, it can be helpful if other employees know to be on the lookout and to warn you.
Thank you for that, Shaina. Mm-hmm. Let's all take a breath for a minute. Again, I just feel like this is such important yet very heavy information. Like this is lots of layers of emotion with the education here. David and Shaina, obviously you are both legal geniuses and real experts in this field. keeping in mind, our audience, what questions might you have for each other, or what sort of items did tonight raise up in your own mind as you heard each other speak? But I want to give you all a moment to dialogue with each other about any questions or items that may have come across your mind this evening.
David, I think that you probably deal with so since I work at Legal Aid, most of the time my clients don't really have a lot of assets or to split up. They're usually splitting up the debt, not the assets. Have you found since COVID how that's been affected in terms of, I guess, how any assets or debts are being accumulated and how they're splitting it up? Have you seen any effects from COVID?
I think the biggest effect that I've seen with COVID is unusual changes in income. And what income, I know that's not exactly what you asked, but I'm going to
No, I do. Yeah.
I'm going to get to that, which is that's been the biggest issue with COVID, which is, is somebody's downturn in their income, is it going to be temporary or is it going to be permanent? And sometimes we're doing guesswork there. So if somebody, has been out of work for maybe 2 months, but now is back to being full-time, okay, well, their W-2 from 2020 is not indicative of their current income, right? But what if somebody's income was reduced by 25% and is still reduced by 25%? What if they are commission-based? What if they are in the restaurant business? I think income has been the most challenging thing to come out of COVID. What is the real income and what is not the real income? I think expenses of parties has been challenging. I mean, how many people here have a gas bill for their car that's a fraction of what their gas bill used to be, right? Well, how long is that going to be going on for? Are we going to be a society that works from home primarily for years to come? Or are we going to be back on that road driving like we have? So I think that that's a challenge. I think the assets and liabilities standpoint from COVID, I think that's more along the lines of just assets and liabilities are the assets and liabilities. I mean, that's what we deal with, whether it's a COVID time or whether it's a non-COVID time. I think the more challenging thing are those child support and those alimony issues. Somebody walks into court, and says, oh, I can't work and COVID has affected my business, or my hours have been reduced, or I'm in the restaurant business. I think those are the more challenging COVID issues that we've been dealing with.
And no childcare expenses a lot of the times now, right? Which was obviously a huge factor for child support before.
You are absolutely correct on that, right? Which is, the no childcare, and is that going to change? And is the childcare going to change? I have a question for you. Have you noticed, and because this is something that I wanted to ask you, have you noticed now over the past, I guess, year, an increase or a decrease in domestic violence injunctions? And because one of the thoughts was, with people home together, right?
Mm-hmm.
Would that somehow, and stuck in the same place, would that lead to more frequent? But then I thought to myself, the counter to that is, oh my God, I'm stuck at home because of the CDC. I don't have places to go. I didn't attend the Coast to Coast Legal Aid workshop today to know that there was women in distress and other things available to me. So I wondered to myself in the last year if people have been less willing to file because they were worried because of the CDC and COVID restrictions that they would have nowhere to go. So,
I think that we definitely have not had any shortage of applications coming in. So it definitely hasn't decreased. It's possible that I believe we are getting more applications than we previously were. I think what you've probably noticed too, David, is maybe divorces are increasing because people are realizing they don't want to stay married to this person anymore the more time that they're with them. So I think that they are related. But like you said, I do think, especially with the active aging population, the combination of the fact that they are more vulnerable to COVID and maybe have more transportation issues and things like that, I think that they may be less likely to go and petition for an injunction. For those people, A.P.I.S is a great resource, for people who are in the senior community, because they can help you petition for the injunction. They can help you appear for Zoom, depending on. So I do think that that's a good resource. But again, if you don't know about it, then maybe you wouldn't be seeking it because you think, how am I ever even gonna leave?
Shaina, what's A.P.I.S?
A.P.I.S. So everybody's probably heard of like C.P.I.S, which is like Child Protective Investigative Services. It's through DCF, also the Department of Children and Families, but it's for adults, as for seniors and for people with disabilities, as opposed to just children. So it is an investigative agency that is responsible for looking into incidents of abuse or neglect, including financial abuse and exploitation, in addition to physical abuse and neglect.
I want to pull Alicia and Nick back into the dialogue as well. Did either of you have any questions that you wanted to pose to Shaina and or David?
Hey, Chris, let me get back in here. Get my microphone up. No, I just wanted to say that my favorite part about these clinics is that I always learn something from them. And David and Shaina have really provided so much valuable information to the community. And it's heavy material and it's very particular, like a lot of things in the law. But I think that both of them did an amazing job really just breaking it down. And then with you, Christopher, of course, like asking them to unpack it because lawyers, we always have that tendency to speak in the way that we normally talk to each other, but breaking it down in a way that anyone watching would be able to understand. So I just want to say hats off because you all did a great job on that.
Absolutely. And I would echo everything that Alicia just said. So a huge, huge thank you to Shaina, to David, to Christopher, and especially to Alicia as well. Amazing information that was covered tonight. And to everybody out there who's watching, I would say, even if the information that you learned tonight, and I think that we've all learned a huge amount of information, even if that's not immediately relevant to you, if you'll do us all a favor and share this video to your own Facebook page, because you never know which of your friends who might be watching this video, this information will be relevant to. That really will do so much for so many folks who are out there. So thank you all to all of our panelists tonight. Really appreciate your time.
Shaina and David, what do you feel like you haven't been able to share tonight that's on your heart that you want to make sure that you share tonight?
I'll start. I guess the thing is, if you believe that you're a victim, if you believe you need protection, don't hesitate to give us a call to apply for our services. Again, either if it's an intimate partner violence, legal aid, coast to coast legal aid, or possibly legal aid services of Broward County. We will be able to, if you qualify for our services, even if we're not able to represent you, we might be able to give you at least some information or some advice about your case. Don't sit and wait because you think it doesn't apply to you. Call the police if you feel you're in danger. A lot of times the police, even if they won't file a criminal case, they'll often tell you, well, I'm not going to arrest them, but you should go get a restraining order. So don't hesitate to look for help in the community because we are here to help you. And unfortunately, it is difficult to do it on your own. And we know that being a survivor of domestic violence or intimate partner violence or any other kind of violence is just the first step toward your journey toward the next chapter of your life. So reach out so that we can try to help you.
This is what I would say. I would say the most common myth is that people believe that divorces have to be World War III, that they have to be the War of the Roses. I think and that's not how I practice, and that's not how I approach it. Obviously, if you have a domestic violence situation, that's different. But if you don't have a domestic violence situation and you're proceeding with a divorce, it doesn't have to be World War III. There are approaches and there are ways to proceed amicably. It is in the best interest of your child or children to try to do it without trauma and drama and stress for those child and the child and children. And so be mindful of that. Be mindful of those things. What you say to the kids, how you proceed, how you communicate it to your spouse. And so that's what I would tell you, is that divorce does not have to mean war.
Such good wisdom, such good information that you were sharing with us. You were both so generous, not only with information, but personal experiences and sharing how this impacts lives and people. I do want you to know, if you're watching, David's contact information going to be in the contacts, Coast to Coast Legal Aid information going to be in the comment section below. Shaina mentioned information about reporting abuse. That information is in the comment section. Adult Protective Services, those will be in the comment section. David mentioned the Supreme Court forums are available, including some for free. That will be below. F.A.C.E.S and that phone number and contact information, that'll be below. Big important thing is open up the comments and take a look at the resources there. And if you are watching this video, as Nick said, please consider sharing it so that the information can get out to folks that may not, not everybody follows the Pride Center or Coast to Coast Legal Aid, but you may have someone in your friend circle or your family or your creative family that really needs this information, and you may be a tremendous lifeline to them. So please share that information with others, and take advantage of this opportunity also to follow Coast to Coast Legal Aid on Facebook, to follow the Pride Center as well. I want to thank also David and Shaina and Alicia and Nick for spending the last couple of hours working on this and spending your evening providing this information. We talk a lot at the center about creating connection and building community. And this is really how it happens. And, I say to folks that when the community center kind of pre-COVID had 1,000 to 2,000 people on the campus a day, I frequently told my friends and family, it's kind of a place where we live our lives together. The center is a place where people get married and a place where people have memorial services for those that die. And we get together to have political rallies and to have moments of reflection. It's a place where people get together to get support in recovery or get support in coming out. If they're an active ager, if they're a young adult, if they're a person of transgender experience, if they're a person of color, it's a place that people connect. And though this material tonight is heavy, it's the reality of what people experience in their lives. And I really just want to thank Coast to Coast Legal Aid and David for providing information that will save lives and that will connect people to each other and connect people to safety and connect people to resources. So thank you for that. Any final comments that folks have, Shaina, David, Nick, before I turn it over to Alicia to wrap us up tonight?
I think everyone's heard enough from me. I think we're ready for Alicia.
Awesome.
All right. Well, I guess I will pop in. I've kind of been hidden a lot, but just learning so much again from David and Shaina, and Nick and I have been messaging back and forth, trying to keep up with all the resources and make sure we have everything for the comment section for everyone. But again, on behalf of Coast to Coast, I say thank you to the Pride Center, because you are an incredible partner to our organization. The work that you do in the community, with and without us, of course, is truly incredible. I said before we started recording that you've done so much lately with your vaccine pop-ups. You have your HIV testing, your other services, your coffee and conversation, which is always, super fun on Tuesdays, and so many other live events. So you all just do a great job. And I wanted to give you a well-deserved shout out for everything that you're doing, that it is appreciated. And just on a personal level, Christopher and Nick, you know how I feel about you. You're just amazing. And I'm so happy to have spent any time like working with you now and in the future, of course. And then Shaina and David, as well, as I've already said, you provided so much incredible information. So thank you again. But yes, once Nick has the information uploaded for Facebook, we're going to add all those comments in and be sure to share it. And to anyone that was attending tonight, like, thank you for spending your time learning and getting to know some of us in different ways, but getting that information and being able to share it with people in the community. It is appreciated.